The story began on a calm cul-de-sac where lawns looked like green carpets and mailboxes stood like uniformed soldiers. A neighborhood that sold the illusion of peace through sameness. A place where every garage door matched the next like a clone smile. For years, that illusion held. Until one letter arrived, a letter that would turn ordinary paint into a weapon. At the heart of this calm street lived Michael Grayson, a software engineer who believed that comfort was built one brushstroke at a time. His home, a pale gray craftsman with white trim, stood as his sanctuary after years of renting cramped apartments. It was his declaration of stability, his first real investment. He spent months restoring it, sanding, painting, landscaping by hand. Every detail carried pride and sweat. For a while, neighbors waved, dogs barked in familiar patterns. The hum of sprinklers filled the early evenings. Nothing suggested the storm that was quietly brewing beneath the beige exteriors. The Homeowners Association, the invisible government of the street, was strict but predictable, until they weren't. One Monday morning, Michael found the envelope wedged beneath his welcome mat, cream-colored paper stamped with the HOA emblem. The kind of envelope that carried authority no one voted for. Inside was a notice titled, "Violation, Non-Conforming Exterior Color." The letter said his gray paint was not in harmony with community standards and demanded he repaint his house beige within 30 days. Failure to comply would result in daily fines. At first, he laughed. It felt absurd, like satire. His home wasn't neon or eccentric. It was tasteful, modest, ordinary even, but the letter's tone wasn't a suggestion. It was law cloaked in courtesy. That evening, as sunset drained color from the street, he stood at the curb and stared at the rows of beige houses. He stood out slightly, not offensively, but enough for a committee that worshipped uniformity. Days passed. He asked neighbors if they had issues. Some shrugged. Some whispered that the board had been targeting non-compliant shades for months. A few had quietly repainted, surrendering to peace over principle. Others warned him not to fight. The HOA president, Linda Rusk, was infamous for her obsession with rules. Her backyard was rumored to have a ruler-marked fence to measure lawn height. Michael decided to check the community handbook, the dense, stapled packet he'd ignored when he moved in. The guidelines were vague. Approved neutral tones was the phrase. Nowhere did it list beige as mandatory. Still, the notice insisted otherwise, a contradiction that gnawed at him. He emailed the board, no reply. He called, was told the decision was final. When he asked for the specific rule number, the line went quiet. Weeks passed. The fine notice followed. $50 per day of continued violation. That's when the calm began to crack, and the story turned from annoyance to escalation. Michael documented everything. Every email, every timestamp, every photograph of his offending paint. He contacted the county zoning department. They confirmed that HOA rules couldn't override municipal code, but HOAs, they explained, operated like private contracts, slippery, complex, difficult to challenge without legal footing. He was told that fighting could cost thousands. Most people gave in before reaching that stage. But Michael had a stubborn streak, a quiet kind that grew in silence. He remembered the years of saving for that house, the sleepless nights debugging code to afford it, and now a committee wanted to rewrite his dream in beige. He decided he wouldn't repaint. The HOA responded with precision. Daily fines stacking like clockwork, certified letters arriving every week, threats of lien placement, whispers spreading that he was bringing down property values. Neighbors began avoiding eye contact. One even crossed the street during his morning jog. It wasn't just about color anymore. It was about control. As the days turned into months, the fines totaled over $3,000. Michael's resolve hardened. He started researching state HOA laws late into the night, scrolling through forums of frustrated homeowners, reading legal blogs, learning how associations abused vagueness to enforce preferences law. He discovered something peculiar, a clause buried in his HOA's declaration that required any color standard changes to be approved by a 2/3 majority vote of homeowners. That vote had never occurred. That discovery changed everything. It turned anger into strategy. He gathered documents, downloaded meeting minutes from the HOA's website, printed screenshots of missing records. One PDF caught his eye: Architectural Committee Annual Summary, 2019. It mentioned updating approved palettes for visual consistency. But there was no record of the vote, only the committee's internal recommendation. That meant the rule wasn't legally adopted. It was being enforced without authority. Michael knew he had leverage, but he needed proof of intentional misuse. He began attending board meetings, sitting quietly in the back, observing. The meetings were polite facades, filled with talk about budget surpluses and community picnics. But behind the smiles, there was hierarchy. When he asked to address the color policy, Linda cut him off. "That issue has already been resolved," she said. The crowd murmured. He noted every reaction. After the meeting, a man approached him in the parking lot. A former board member who quietly said, "You're right, they never voted. But be careful." That warning lingered. It wasn't fear, it was confirmation. Back home, Michael drafted a letter, not to the HOA, but to their management company. Formal, factual, emotionless. He cited the state statute governing common interest developments. He pointed out the missing vote. He requested immediate suspension of fines and an audit of enforcement procedures. Then he waited. Weeks of silence followed. But beneath that quiet, something stirred. The HOA board met privately. An emergency session. Whispers circulated about a homeowner challenging the process. Linda doubled down. New letters arrived, claiming his tone was disrespectful. They threatened arbitration, another fine. That was the moment Michael decided this wouldn't end with a compromise. It would end with exposure. The first signs of retaliation came quietly. A notice about weeds that didn't exist, an email accusing him of leaving his trash bins out too long, warnings stacked like a paper fortress meant to wear him down. Each one arrived with precise timing. Each one signed by the same initials, LR. The message was clear. They wanted compliance through exhaustion. Michael responded with precision. He photographed every alleged infraction, time-stamped, dated, cross-referenced with weather data. He didn't send emotional replies, only calm, methodical rebuttals. The more he documented, the more errors he uncovered. Notices cited rules that didn't exist. One referenced a new trash policy that had never been adopted. He began to see a pattern. The HOA wasn't enforcing standards, they were inventing them. What started as a disagreement about paint had become a power contest. One man against a machine built on bureaucracy. Late nights blurred into early mornings. His dining table transformed into a war room. Binders of evidence, color printouts of emails, highlighted lines of bylaws. He wasn't a lawyer, but he was becoming something close. Disciplined, strategic, relentless. Then came the breaking point. A letter arrived marked Notice of Intent to Lien. The HOA claimed $4,350 in unpaid fines and administrative fees. If unpaid within 15 days, they would record a lien against his property. It wasn't just intimidation, it was escalation. A lien meant his home, his sanctuary, could be leveraged against him. He sat at his kitchen table, letter trembling slightly in his hand, the beige walls surrounding him like a prophecy. For the first time, fear crept in, not of losing money, but of losing control over his life. He looked out the window. Every other house mirrored the same pale tone the HOA demanded. His stood out, not by color, but by defiance. That night, he made a decision. He would fight legally. Not reactively, but offensively. He reached out to a local property attorney known for HOA disputes, Carla Navarro, a quiet but razor-sharp specialist who'd built a reputation dismantling overreaching boards. She reviewed his file in silence, page by page. Then she looked up and said the words he'd been waiting to hear. Though in narration form, they echoed like revelation. There was a case here, a strong one. Michael learned that the HOA had violated procedural law by enforcing an unratified rule. In his state, any change to design standards required not only a majority vote, but also proper filing with the county clerk. The HOA had done neither. Every fine issued under that clause was technically void. Navarro crafted the blueprint, A cease and desist letter first, demanding immediate withdrawal of the lien threat and reimbursement of fines. If they ignored it, she would file a civil complaint for breach of covenant and abuse of authority. For the first time in months, Michael slept soundly. Days later, the HOA received the letter. It was brief, direct, and legally surgical. The management company panicked. They forwarded it to the board. Internal emails circulated, some of which Michael would later obtain through discovery. Messages where board members debated whether to make an example out of him. But they didn't know what was coming. 2 weeks passed. No response. Then a knock at his door. It was a process server, ironically delivering their lawsuit against him. The HOA had decided to sue first, claiming non-compliance and defamation. They accused him of damaging the HOA's reputation by spreading misinformation. Michael smiled, not out of arrogance, but understanding. They had just made the biggest mistake possible. By suing, they opened themselves to full legal discovery. Everything would have to be disclosed: emails, votes, budgets, internal communications. Carla was ready. She countersued, filing a response that not only denied their claims, but expanded them, adding counts for fraudulent enforcement, harassment, and emotional distress. The neighborhood buzzed with rumors, some sympathetic, others suspicious. The beige houses seemed quieter, blinds half closed as if the community itself was holding its breath. Meetings grew tense. Some residents began questioning the board's leadership. A few even thanked Michael quietly in passing, whispered words of support between mailboxes. Meanwhile, the case advanced. The HOA's attorneys sent settlement offers, vague proposals if he agreed to repaint and waive restitution. Michael refused everyone. He wasn't after revenge. He wanted accountability. Months of filings followed. Depositions were scheduled. Lawyers traded motions. Through it all, Michael remained composed, his calm demeanor contrasting sharply with the HOA's frantic responses. He knew that every overreach, every procedural misstep strengthened his hand. Then came the moment that cracked the case open. During discovery, Carla obtained an internal email chain from the HOA's architectural committee. One message from Linda herself read, "We need to make sure everyone complies. The vote can wait. Enforcement first." Those words were gold, legal proof that they knowingly enforced an unapproved rule. The tone of control was undeniable. The case shifted overnight. What began as a homeowner's frustration became a matter of organizational misconduct. The HOA's insurance company, responsible for legal defense, grew nervous. They quietly contacted Carla. They wanted out before the damage spread. Negotiations began, silent, cautious, strategic. While the lawyers talked, Michael reflected on the journey, how a bucket of paint had revealed a system built on fear. He saw the pattern everywhere. Neighbors too tired to argue, too polite to resist. Beige wasn't a color anymore. It was a symbol of obedience. Weeks later, the first settlement draft arrived. The HOA offered to cancel all fines and drop the lien threat. In exchange, Michael would dismiss his countersuit and repaint within 60 days. He declined. He wanted more: transparency, reimbursement, and a public apology. The board refused, pride outweighing reason. So the case moved toward trial. Local news caught wind. A headline appeared: "Homeowner fights HOA over paint rule. Lawsuit exposes procedural flaws." Cameras showed up at the next HOA meeting. Microphones hovered over the podium. The board looked uncomfortable, Linda especially. That's when the power began to shift. The HOA's control thrived in secrecy, and now that secrecy was gone. Michael remained quiet, deliberate. He let the facts speak. Each new filing pulled another thread, unraveling a system that relied on silence. By the time pretrial mediation arrived, the board was fractured. 2 members resigned. One filed a complaint against Linda for ethical misconduct. The HOA's management company terminated their contract, citing loss of client confidence. And yet, Linda refused to yield. She vowed to see it through. That vow would cost her, and the HOA, far more than repainting ever could. The legal nightmare was only beginning to unfold. but the leverage was now firmly in Michael's hands. Winter settled over the suburb like a hush. The lawns turned brittle. The beige walls lost their warmth. And yet, beneath the frost, tension simmered. The lawsuit that had started as a neighborhood dispute had grown into a community-wide reckoning. And for the first time, the HOA found itself under a spotlight it couldn't control. The courthouse sat 20 miles away, a stone-faced building that looked indifferent to human pride. But inside those walls, everything would be stripped to evidence and law. Michael walked its corridors quietly, a man carrying more than a case file, carrying months of humiliation, fear, and principle. Carla Navarro walked beside him, composed as ever, her briefcase heavy with facts that could undo a board built on intimidation. The pretrial motions had already gone badly for the HOA. The judge, a meticulous reader of statutes, had denied their request to dismiss Michael's counterclaims. She ruled that evidence of procedural misconduct was substantial and relevant. That single line in the court record changed the tone. Would have been a nuisance suit now smelled like accountability. Depositions began, long hours in neutral conference rooms, stenographers capturing every breath. Board members shuffled papers, avoiding eye contact. Linda Rusk sat stiff, choosing her words like a person stepping through a minefield. Carla's questions were quiet but cutting, each one tracing a thread back to the missing vote. Was there ever a homeowner's ballot approving the 2019 color standard? Linda hesitated. The pause hung heavy. She finally answered no. The silence after that single word carried more weight than any argument. Over the following weeks, Carla revealed internal memos, handwritten notes from committee meetings, and inconsistencies in fine records. Payments collected before official notices were even dated, signatures missing from approval logs. The HOA's defense began to fracture, their own paper trail turning into evidence against them. Outside the courtroom, the neighborhood watched. Some residents whispered that the board deserved it. Others worried about rising legal fees that would fall back on them. A petition circulated to suspend the entire committee until the case ended. The once tight cul-de-sac now carried a quiet civil war. Lawn greetings replaced with avoidance. Beige siding now a symbol of embarrassment. Michael stayed away from the gossip. He spent his evenings in the same gray-painted home they had tried to erase. The house that had become both battlefield and refuge. He sometimes sat in his driveway at night, headlights off, watching the stillness, wondering how far people would go to protect power built on fear. Then came the trial. The courtroom was small, beige walls ironically matching the subject of the dispute. The gallery filled with residents, reporters, and a few curious lawyers from nearby firms. They knew cases like this could set precedent. Carla opened calmly. She didn't dramatize. She told the story through facts. This homeowner complied with all recorded regulations. The association acted without a lawful vote. They enforced a rule that did not exist in binding form. They fined, threatened, and attempted to lean, knowingly outside their authority. Her tone was surgical, each sentence trimmed of emotion yet filled with gravity. The HOA's attorney, red-faced and defensive, countered that the board acted in good faith. But good faith collapses under evidence. Carla introduced the email, the one where Linda wrote, "The vote can wait." The judge leaned forward, asked the board president to confirm a message. Linda tried to explain it away, called it a misunderstanding of timing. But the damage was done. The jury saw intent. Witness after witness took the stand. A neighbor who'd repainted reluctantly testified that she never received notice of a color vote. Another admitted the board told her it was policy, not up for debate. Patterns emerged. Patterns of arbitrary enforcement, selective punishment, favoritism toward friends of the board. By the third day, the HOA's narrative had collapsed into paperwork contradictions. The judge ordered a recess. Whispers filled the courtroom. Even the reporters sensed a shift. Michael sat still, hands folded, the exhaustion of a year's battle etched beneath his calm. Carla turned to him and said softly, though through narration it felt like a heartbeat between storms, that they were winning. When the trial resumed, the HOA's defense called its final witness, Linda herself. She spoke of community harmony, of protecting property values. But under cross-examination, the harmony dissolved. Carla read from the association's own handbook, pointing out every procedural violation, every skipped vote, every misfiled record. The jury listened, eyes steady, expressions unmoved. Closing arguments came like the quiet before a verdict. Carla summarized everything not as outrage, but as inevitability. When power is unchecked, it becomes convenience. When convenience becomes rule, the rule of law disappears. The line echoed through the courtroom like a sermon. The HOA's attorney focused on money, claimed that if Michael won, every HOA would face ruin. But juries don't fear abstractions. They respond to truth. Deliberation lasted less than 2 hours. When they returned, the foreperson read the verdict. The HOA was found liable for wrongful fines, procedural misconduct, and emotional distress. The court ordered them to void all fines, pay Michael's legal fees, and compensate him for damages totaling $48,000. Gasps filled the room. Reporters scribbled. Linda stared blankly at the table. But the verdict wasn't just numbers. It was validation. Michael hadn't just won a case. He had pierced the illusion of authority that had ruled his street for years. Outside the courthouse, winter sunlight broke through low clouds. Cameras followed as he stepped onto the steps. He didn't speak dramatically, just nodded once, as if closing a chapter. Carla smiled faintly. She had seen hundreds of disputes, but few where principle outweighed profit. Back in the neighborhood, something changed. The HOA board called an emergency meeting. Residents demanded transparency. Votes of no confidence were filed. Within a week, Linda resigned. The management company dissolved its contract entirely. A new board formed, one that promised public votes and recorded minutes. Michael's gray house still stood out, but now, instead of resentment, it drew quiet respect. He repainted the trim, not beige, not to comply, but a deep slate blue, subtle, dignified, a mark of endurance. In the months that followed, the community slowly healed. Conversations returned. Neighbors waved again, but the myth of absolute HOA control had cracked forever. And through that calm, one truth remained. Control built on silence only lasts until someone decides to question it. The verdict echoed far beyond one cul-de-sac. Ripples of consequence spread through boardrooms and backyards alike. What began as a fight over paint had evolved into a quiet revolution against unchecked power. Local papers framed it as the Beige case. Talk shows debated whether homeowners associations had become too powerful. Law blogs dissected the ruling for its precedent value. Other residents, miles away in different towns, downloaded their own governing documents for the first time. Some found the same hidden flaws. For Michael, the noise felt distant. He didn't crave fame. He craved normalcy. Yet normal would never feel quite the same. His mailbox overflowed with letters, some from grateful strangers, others from homeowners still trapped in similar battles. He read every one, quietly, humbly, sometimes setting them aside just to breathe. The neighborhood, once defined by fear of the board, began to rediscover its voice. At the next community meeting, attendance tripled, chairs filled with people who had once stayed silent. The new board president opened with a statement of reform. Transparent votes, public budgets, rotating committee seats. Applause followed, hesitant at first, then sincere. Linda Rusk disappeared from the public eye. Rumor said she sold her house and moved 2 counties over. Her name, once whispered with authority, now carried embarrassment. The management company rebranded, replacing their logo, but not their reputation. The stain of the Beige case followed them online. Michael spent spring rebuilding what stress had stripped away, weekends planting trees instead of gathering evidence, evenings walking his dog through streets that no longer glared at him. Children played again. The cul-de-sac felt like a neighborhood instead of a jurisdiction. But peace didn't erase memory. He kept one binder from the case, thick with highlighted pages, court orders, and the original notice demanding beige, a reminder of how fragile autonomy could be. Sometimes he opened it, tracing the lines of his own notes, the handwriting tight from those long nights at the dining table war room. He'd stop at one page where he'd scribbled a sentence in the margin. Power unchecked becomes habit. That sentence became his quiet mantra. Months later, an email arrived from a law professor asking permission to use his case in a civil governance seminar. He agreed, not for credit, but so future communities might learn that rules, without accountability, breed corruption. He returned to routine, work, family, the steady rhythm of ordinary life. Yet sometimes, while mowing his lawn, he'd glance at his slate blue trim. The color had become more than paint. It was defiance turned into dignity. Summer came, and with it, a calm he hadn't felt since the first envelope appeared. The fines were gone. The lien threat dissolved. The legal fees reimbursed. What remained was the quiet satisfaction of someone who had stood his ground and proven that one voice, patient and prepared, could reset an entire system. The neighborhood newsletter ran a short feature. Homeowner wins case. Community moves forward. It ended with a quote from the new president. Transparency is the color of trust. The line felt rehearsed, but still, it meant progress. Life slipped back into its slower rhythm. Sprinklers hummed at dusk. Porch lights flickered on. The street, once an arena, felt human again. And yet, every now and then, a new family would move in, look around at the palette of varied shades, and ask why one house stood gray and proud amidst the soft beige. Someone would smile and tell them the story, not of rebellion, but of principle, of how one homeowner reminded everyone that uniformity is never the same as unity. Michael never corrected them. He'd just wave from his porch, the evening sun catching the hint of blue on his trim, a small gleam of quiet victory. Because in the end, his house didn't just keep its color, it kept its voice. Time moved differently after the storm passed. Days no longer measured by deadlines or legal filings, but by quieter markers. Sunrise over dew-coated grass. The smell of fresh paint from another home down the street. The sound of laughter returning to sidewalks that once held only whispers. Michael often wondered what the fight had truly cost him. The sleepless nights, the drained savings, the toll on patience. Yet beneath the exhaustion there lingered a strange gratitude. Struggle had stripped away illusion. It had revealed how fragile fairness could be when convenience ruled over conscience. He didn't see himself as a hero, just a homeowner who had refused to shrink. But the narrative, once private, had taken on a life of its own. Civic podcasts dissected his strategy. Local students invited him to speak about grassroots governance. He stood at the podium once, nervous hands gripping the sides, and told them that law was only as strong as the people willing to read it. Applause followed, not thunderous but real. The case changed more than policy, it changed perception. Neighbors began speaking to each other instead of about each other. Disagreements still happened, but now they ended in conversation rather than letters of violation. The board discovered that transparency wasn't weakness. It was trust built in daylight. One autumn evening, he sat on his porch watching the wind stir the leaves into spirals. The same street lamps that once felt like surveillance now looked like sentinels guarding peace. He thought about all the hours spent proving a point that should have been self-evident, that ownership means stewardship, not submission. He smiled faintly. The color beige still appeared here and there, neutral, harmless, a background hue, but it no longer symbolized obedience. Each home, repainted in shades of cream, gray, green, or brick red, carried its own quiet declaration. Difference is not disorder. Letters still arrived, some months apart. People writing from other towns where new disputes brewed. They told him his story gave them courage to question unfair rules. He replied when he could, careful to remind them that patience and evidence were stronger than anger. Fight smart, he wrote once, not loud. There are no more courtrooms, no more headlines, just life, lived deliberately. The binder of documents found its permanent place on a shelf beside gardening books, occasionally dusted, never forgotten. On its spine, a single label. The beige case faded slowly with time, like a scar softening into memory. Years later, a new family bought the house next door. One evening, the husband asked casually about the unusual shade on Michael's trim. Was it special order? Michael chuckled. You could say that, he replied, and left it at that. The story would travel again, as stories do, from porch to porch, from neighbor to newcomer, each retelling shorter, gentler, but carrying the same pulse of defiance. And that was enough. In the broader world, laws continued to shift, associations continued to argue, but the Beige case remained a footnote in legal journals, a precedent on fairness, proportional enforcement, and the right to expression within private governance. Small, yet significant. As twilight deepened, he turned off the porch light and watched the last glow fade across the slate blue walls. The colors seemed to breathe in the darkness, steady and certain. For him, the hue meant something no board could legislate, dignity earned through endurance. The camera would fade slowly here if this were film. The narrator's voice soft, measured, deliberate. In a world that prizes conformity, sometimes the boldest act is simply to stand still, paintbrush in hand, and say no. The screen would dim, the story ending not in triumph or defeat, but in balance. Justice, after all, is not about revenge, it's about restoration. And sometimes it starts with something as small and as symbolic as the color on a house. Fade out. Silence. Then the faint sound of wind brushing against wood siding. Steady, rhythmic, free.